Hi, everyone. Thanks so much for joining our session today on the invalidation of the Privacy Shield. I'm Samantha Graham, Brand Marketing Manager at Mixpanel. Today, we're joined by our resident expert, Mixpanel's Global Head of Privacy and Security, Peter Day. Before we get started, I just wanted to run through a few quick housekeeping items. First off, if you have any questions, we encourage you to submit them through the Q&A function in the Zoom. You can also use the chat widget, but we recommend using the Q&A. Secondly, our webinar is being recorded today, so don't feel any pressure to take hurried notes. You'll receive a copy of the recording within the next 24 hours, and you can refer back to it, review it, and share it around with your team. If you find that you have any technical difficulties or are having trouble hearing, you can check the audio carrot. You'll also be muted upon entering, so no worries about us seeing you or hearing you. We got a lot of questions about this already and suspect that there will be a very high volume today. So if we don't get to your question, don't worry. We're going to be continuing a conversation on Mixpanel's community platform, QBQ. I'll send around the details afterwards in our follow-up email along with the recording. Lastly, while we really encourage you to ask questions, this is not a webinar that's meant to give any specific legal advice. So just make sure that we're talking about general themes when you ask your questions. And with that, I'd like to hand it off to Peter.
Yeah, thank you, Sam. And good morning or good afternoon to everybody. As Sam mentioned, my name is Peter Day. I'm the head of Mixpanel's Global Privacy and Security Programs. I'm an attorney. I received a JD from Indiana University, Maurer School of Law, and I've been practicing privacy and international data law for almost 10 years now. Prior to joining Mixpanel, I worked as a privacy officer for part of the Federal Reserve System, which is the US central banking system. And I am an avid surfer. So very glad to meet you all today and excited to talk through a pretty dramatic couple of days in the privacy space. So not to bury the lead too much, but the headline here is that the European Court of Justice, which is their equivalent to the Supreme Court, we will refer to them as the CJEU, has invalidated one of the key international data transfer mechanisms that has allowed US and other countries to get information from European Union residents out of the European Union in a manner that complied with GDPR. The case itself, which we're referring to as Schrems II, involved three parties: the Irish Data Protection Commissioner, Maximilian Schrems, an Austrian privacy advocate, and Facebook. So what happened? We're going to dive into this a little bit more in a moment, to set the tone and establish a few key and shared talking points for our discussion today. But briefly, as mentioned, the CJEU invalidated the Privacy Shield, but it did preserve another very important transfer mechanism called standard contractual clauses, sometimes referred to as model clauses or SCCs. We'll be referring to them today as SCCs, but they're all the same thing. So in a takeaway point, I wanted to just explain that while the situation is muddled, and it is going to change radically over the next couple of days and weeks as the implications of the CJEU's decision in Schrems II is digested, there are some things that we think you can do now to help ensure you're set up for success as the Schrems II case works out. And I'll talk through a few of those briefly. And also, I'm happy to answer your questions. And that's really the point of today's call, is to make sure that you have space to ask whatever questions you want, so that we can engage in a discussion about how to respond to this very important decision. So to begin with, I thought it would be helpful to establish some context. Who is this Schrems guy? Why is it so important? And where did this come from? So Max Schrems appears on the scene in 2013, 7 years ago now. And he files a complaint with the Irish Data Protection Commission about Facebook's use of what preceded the Privacy Shield, which was called the Safe Harbor Framework. And he complained that they were not protecting individual rights in a sufficient way. But what really triggered Schrems initial complaint wasn't Facebook, it was our dear friend Edward Snowden. So as those of you who remember back in 2013, this is when Edward Snowden disclosed the PRISM program, which really highlighted the National Security Agency's then common practice of doing bulk data collection for non-US persons. And that's really what triggered this entire thing. So if we're talking today about Privacy Shield, we have to keep in mind that the triggering mechanism were the Snowden disclosures. In 2015, Schrems 1, the initial complaint, was ruled on by the CJU, the same court that issued its opinion last Thursday, and it invalidated the safe harbor framework. Shortly thereafter, Facebook pivoted and started offering what are called standard contractual clauses. And around the same time, Max Schrems filed the instant case, Schrems 2, again with the Irish Data Protection Commission, seeking to invalidate international transfers under the standard contractual provisions. So in between Schrems' second case and today, the US Department of Commerce and the European Commission created something called the Privacy Shield Framework, which was seen as a replacement for the old Safe Harbor framework and a way to ensure that European residents' data was protected in a way that was equivalent to the GDPR when it was transferred out of the European Union to the United States. In 2017, as our saga continues, the Irish Supreme Court, which had heard a DPC or Irish Data Protection Commission complaint about Schrems, referred Schrems' case to the CJEU, setting up the decision last Thursday about the validity of the Privacy Shield framework and standard contractual clauses. And then obviously, as we've all seen, on Thursday, the CJEU invalidated the Privacy Shield framework, but upheld standard contractual clauses. And so you've been looking, in my opinion, at one series of complaints involving Max Schrems and Facebook that stretches back 7 years. And you've seen a huge amount of international effort, jurisprudence, and just activity around this single complaint that stretches back to the Snowden disclosures. So what did the CJEU say last Thursday? So the first thing, and I think the big highlight, is obviously that the Privacy Shield is invalid. And the reason it's invalid is it looked at the way in which US intelligence law allows US intelligence agencies to collect information on non-US persons. And the CJEU specifically held that the amount of intelligence information collected in the US is out of proportion to any use, which is a pretty extraordinary finding to have a court in another country rule on a third country's intelligence practices. It also found that the the Privacy Shield framework and current US law did not provide adequate judicial protections and legal protections to non-US persons who were having their information collected by law enforcement or intelligence. And I think that the decision itself, when you look at it and you look at the whole context, especially stretching back to the Snowden disclosures, will leave some clues as to how to draft a strategy to address this decision going forward. And we'll talk a little bit more about that later in today's presentation. And finally, I think it's important that the decision itself leaves enforcement uncertain. While it invalidates the Privacy Shield framework, it doesn't include an express reference as to when or how enforcement will continue, or when and how data transfers made under the Privacy Shield framework will be enforced by any data protection authority. So in short, Privacy Shield's life is still somewhat maybe continuing on, if you will. The second key finding in the decision is that the standard contractual clauses, another mechanism for data transfers, remains valid. They're deemed to provide an adequate level of protection and safeguards. That was an express finding, but the court continued to hint that you may need more than just your standard SCC. And the court did that by focusing on a term called essential equivalence. The court seems to want data controllers to ensure that any processors who are processing EU data out of the European Union can provide assurance that their practices are essentially equivalent to those offered under the GDPR and other European privacy laws. And the court called out a couple of new players who may take on increased importance when you're drafting SECs. These are local data protection authorities. There's also pre-transfer assessments, maybe an enhanced form of diligence, and other protective measures like doing security reviews. And we'll talk a little bit about that in a moment. And finally, I just want to call out that it's important to note that the court didn't invalidate other transfer mechanisms under the GDPR. Things like BCRs or binding corporate rules remain valid. You can still do transfers under derogations if you have consent. And so there are options for getting data out of the European Union in a way that is continue to comply with this decision. And it also, I think, points to a possibility that some of those mechanisms may themselves come under review for the same reasons that led the court to invalidate Privacy Shield and to consider SECs. So while they remain, it's important to keep them in context and perhaps start to consider options like data residency programs and data localization programs. So given the increased importance of regulators, particularly under the CJEU's decision and the fact that they're going to be framing enforcement going forward, I thought it would be helpful to discuss briefly what we've heard so far. And this is coming fast and quickly. So although we drafted these slides yesterday morning, there have been changes even today. So don't take this as an authoritative list of what's going on. But I do think the trend here is to see a spectrum of responses. You've seen some people criticize the decision, particularly in the Anglosphere, and then you've seen others, particularly in Germany, think that the decision might go beyond what we read it as saying. So here's some of the key statements that we're going to call out today. The first one is the European Data Protection Board, and I think they're really going to emerge as one of the key players when they do issue guidance on the Schrems II decision. They have welcomed the decision. They think it's a good sign for data subject rights. However, they continue, and they hint here, to play a constructive role in transatlantic transfers, meaning that they don't see a situation where it would be impossible for European companies or American companies doing business in Europe to transfer EU data out of the European Union. On the other end of that spectrum, we see the US Department of Commerce, Secretary Ross has said that he feels that the Privacy Shield framework was valid. He was disappointed in the decision. He also noted, and this is somewhat bizarre, that companies that have certified with the Privacy Shield framework will continue to be obligated to live up to their commitments. And this means that you could still face potential enforcement from the Federal Trade Commission if you begin to stop processing data in line with the Privacy Shield frameworks, but your privacy notices, your contracts, or anything that you use to collect data stated that you would. So important for American processors and controllers to keep in mind that their Privacy Shield obligations are, at least for now, continuing. The United Kingdom has taken an interesting approach as well. With Brexit, they've been looking to build up the transatlantic trade relationship. And I think you see in the Information Commissioner's Office announcement a real keen sense that they want to continue to facilitate transatlantic data flows. They expressed some disappointment in the decision and have signaled that they want to support data transfers. And so this leaves open the option that some version of Privacy Shield could continue between the US and the United Kingdom. And finally, on the very end of the extreme, we see something like the Berlin Data Protection Commissioner's press release. And it's important to note this is a press release. It was not a binding regulatory order or some other official document, just a press release expressing serious doubt on, even with SECs, whether Berlin-based controllers could send data to the United States for processing. And we've seen some other German DPAs, particularly Hamburg, take a similar approach. So with all of this going on, Privacy Shield gone, regulators sort of all over the place about what to do, what do we do now? I think there are a couple of key points, but the first and the most important point is to stay calm. When Safe Harbor was invalidated, it took some time to figure out a new process. There was a lot of uncertainty, but it did come into focus rather quickly, and companies were able to make decisions that allowed them to preserve appropriate transatlantic data flows. And so we think it's necessary here to stay calm as well and listen to regulatory guidance, don't engage in any knee-jerk reactions, but to remain calm. I think two, it's time to really begin focusing on standard contractual clauses. They were specifically upheld by the CJEU, and I think they've now had that imprimatur and so are safe to begin negotiating with your processors, joint controllers, and any sub-processors that you're in direct privity with. So I think that's a great time to look at your technology stack, look at your partners, and say, hey, now's the time to start looking at these SECs and exploring them. And I think they are a good alternative transfer mechanism, at least for the time being. However, and I think this last point's key, SECs are no longer just a check the box exercise where you download them from the European Commission website, you send them over and they're signed. I think what you see in the Schrems decision is a real focus on looking beyond just technical compliance and doing some diligence to ensure that your counterparty takes data protection and privacy seriously, and that has mechanisms in place to ensure that there are adequate protections that are, and this is the court's term, essentially equivalent to those provided for under the GDPR. So we think you're going to start to see things equivalent to data privacy impact assessments or other types of assurances that are going to be required to execute defensible SECs going forward. So again, these are some high-level themes, some grist for the mill, if you will, on questions. But really the point of today's webinar is to give you all a space to ask me anything that you want and to engage in a dialogue about how to address the Schrems decision, how it may impact various transatlantic data flows, and other questions related to how to address this very exciting decision. So with that, I'm going to turn it back over to Sam. And she will moderate the questions and answers.
Terrific. Thanks, Peter. So our first question is, Peter, you mentioned CJEU is looking for more than just standard contractual clauses. Can you elaborate a bit more on what you think will be required?
Yeah, so it's a very good question. One of the things that we see the CJEU decision focusing on was Article 45 of the GDPR. You're like, Article 45, what does that mean? Well, in a nutshell, Article 45 is how the European Commission is to determine whether a third country is adequate and it provides adequate levels of legal protection to data subjects. And so it's things like, do they have judicial redress? Is it likely that an intelligence agency would collect information? And we recommend that you take Article 45 and you marry it to some of your information security practices like encryption in transit, encryption at rest, and you produce what is essentially a private adequacy decision showing that your service, when equipped with SECs, meets all of the obligations that a data subject would need under the GDPR. And we think that would be a very defensible approach to dealing with the Schrems II decision.
Wonderful. Thanks, Peter. Our next question is it okay to host data on AWS Ireland servers? We will need to transfer everything from our AWS US servers to a Europe-based one.
Yeah, that's a great question. And it goes to some of the heart of what we at Mixpanel are working on, which are data residency solutions. I think when you're talking about AWS Ireland, if the data is in Ireland, it's not leaving the European Union. And so transatlantic data transfers out of the European Union do not apply. And so you're really avoiding the Schrems decision by moving data into an EU-based data residency or data localization option. So a great solution to these types of problems.
Wonderful. Our next question is there a timeline regarding the mentioned data residency solutions Mixpanel is working on?
So we're going to have some exciting news about that shortly, but it is going to be in the very, very near future. We'll be excited to share some more information about our residency options and other options designed to help global controllers and controllers based in the European Union manage risks associated with data transfers.
Awesome. Now for our next question. In the event that you are relying on Privacy Shield as a transfer mechanism to a cloud provider, is it lawful for the cloud provider to charge you to migrate data to a EU data center to remain compliant?
This is a great question. And I think it's one that focuses on commercial relationships with your counterparty. So for example, if your counterparty has been transparent in their pricing, or if they have an existing contract with you, those would really govern the outcome of this decision. However, there's nothing expressly in the GDPR that prohibits commercial parties from charging each other fair services or fair fees to meet compliance obligations or meet technical or electronic logical controls that are necessary to meet those compliance obligations. You see payment limitations and rights around that more focused in the consumer space, but when it's B2B, those are rarer. So again, I would strongly consult your contract and look at the circumstances surrounding your procurement of those services, but there's nothing express in the GDPR that you could point to and say this prohibits this behavior.
Great, thanks, Peter. Our next question asks, accessing data from another country, e.g. viewing the data from the US, is still considered a data transfer, correct? So if you are an international company doing 24/7 support from multiple locations, would data residency still be sufficient?
This is a good question, and one that we've wrestled with a fair bit at Mixpanel. I think it comes down to individual controllers' risk assessments. So for instance, if you are providing 24/7 support, are they engaged in processing? I think the answer is it depends on what they're looking at. They may not be looking at any personal data, in which case the GDPR and the data transfer rules don't apply. They may be looking at anonymous data, which means it's also not applicable. Or they may be able to provide support from that jurisdiction. So some companies, including Mixpanel, have stood up programs where they have support on a regional basis. For example, European Union support unit, a North American support unit, and an APAC support unit. And we think that is going to accelerate the trend where you have more regionalized support to avoid these types of situations where companies and individuals who are very concerned about privacy, who have a lower risk tolerance, let's say, want fully localized services. And we're going to begin to see more of that, I think.
Great. Our next question here is, what kind of practical steps can be part of an execute SEC move?
Sure. So the first step, I think, is to identify the risks associated with your customers and user base. And we think that you can incorporate SECs by reference into an existing data protection addendum. And as long as you can get some sort of objective manifestation of consent or agreement to that new form, you should have a valid SEC. So these would be things like checkboxes. These would be things like wet signatures or e-signatures, all of which are enforceable in the European Union. And we think the final point that I would make is one about risk. We think, given the volume that many cloud service providers and other companies have of customers, you should really rank your customer base into those that are going to take SECs very seriously. So we call those your core group. Customers who are concerned about this but are more willing to look at standard terms, and then those customers who may be on just your standard terms. And we would move through them in that order. So identify your core customers, reach out to them proactively, and seek to have them execute SECs as quickly as possible, or whatever other type of transfer mechanism they're comfortable with.
Terrific. Thanks, Peter. Here's another question. My company is strictly committed to data segregation already. We keep data of EU citizens in Europe and US ones in the US, but we also use Mixpanel. How can we get guarantee that Mixpanel data of our EU users are kept in Europe?
So it would depend on your precise architecture, but in general, Mixpanel's SDKs are highly flexible. And so you can have certain deployments of the SDKs resolved to our European data center, or you can have them resolved to our North American data center. They would, though, have to be in separate projects or organizations for the time being. So it could be difficult to get a global view of your data. We tend to recommend that you choose a cluster. Given the computing power that we have in both clusters, it is possible to have the European cluster be a global hub. So that might be one option to consider. But again, it would come down to your specific use case and the solution you're hoping to architect. And thankfully, we have a very strong solutions architecture team and professional services team at Mixpanel who can help you walk through those issues, and they're in touch with me frequently so we can get the benefit of having the privacy program weigh in if appropriate and warranted.
Great. Next up, how will third parties / cloud providers that store data in the US be impacted by this? Are any providers excluded from requiring a DPA or SCCs? In particular, cloud providers that store only login details for admin accounts but no other personal data. Think SurveyMonkey to collect anonymized surveys. The only data is the personal data to log into SurveyMonkey.
One of the most frustrating aspects, I think, of the GDPR is it doesn't have concepts like quantum of risk, and those aren't really built in. And it just says, if you transfer personal data, you must comply with these controls. And so anything that meets the definition of personal data, which you can find in Article 4 of the GDPR, technically triggers these obligations. To back up slightly, there was also embedded in that question, are there any companies that are excluded from this, or are there any special carve-outs? And the answer is no. These apply generally and across the board. However, companies that have binding corporate rules in place or have already executed SECs, they're not immediately impacted. But again, I do think that you are going to see some additional activity in that space. However, to answer the question behind the question is, how much data is enough to trigger risk? And I think that's really an individual decision. However, I do think it's a risk-based approach. Is a data protection authority going to take action against a company who is only really transferring login data versus a company who is doing bulk collection of consumers' personal information and transferring that all over the globe? I think those are two very different risk cases. But again, that's a very individual decision, which each company will have to make for itself in the coming days and weeks.
Thanks, Peter. Our next question is, can you tell us whether the Privacy Shield is still valid for data transfers from the UK?
I wish I could. The short answer is the ICO, the British Information Commission Officer, the lead regulator, and Her Majesty's government have both issued press releases in light of Schrems, strongly suggesting that they disagree with the decision, that they're keen to allow for continued data transfer, and that they hope to participate in something like the Privacy Shield. It's my strong guess that with Brexit, the European Union, the UK government will continue to allow transfers under Privacy Shield. The wrinkle here is the UK government is also seeking an independent adequacy determination from the European Commission. And we don't know and won't know for some time whether the European Commission will see the UK government's eagerness to send data to the United States as a sign that it does not provide adequate determination, adequate protections. That could be a worst case scenario for the UK government, given the importance both of trade with Europe and the United States. So I wish I could give you a crystal ball view here, but right now it's a strong TBD.
Understandable. Thanks, Peter. That was helpful. The next question is, would you recommend model / standard contractual clauses or binding corporate rules?
So in general, the privacy rule of thumb is binding corporate rules are always better, and standard contractual clauses are great, but they're not as strong as binding corporate rules. So the immediate reaction is, great, I want to go get a binding corporate rule. Well, the challenge with binding corporate rules is that they require approval by your lead regulator in the European Union, and no regulator has been issuing binding corporate rules decisions for months, and they're very understaffed. We don't see them issuing binding corporate rules anytime in the future. So while that is certainly stronger, I think in practice, it's almost impossible to get them. So I do think we're looking at a situation where we can't let the perfect be the enemy of the good, and we should be pursuing standard contractual clauses or other transfer mechanisms. But BCRs, although not impacted by Schrems, are practically very challenging to get, or at least they have been up to this point.
Great. And on the topic of standard contractual clauses, our next question asks, do you think that additional safeguards are needed for data transferred to the United States under standard contractual clauses? And if so, what do you recommend would be for such additional safeguards?
Terrific question, very thoughtful. I do think that additional safeguards are warranted. And I think the court made that rather clear, is they don't want just check the box SECs. So what does that look like? I think one, it looks like doing a risk assessment about whether or not the data you're transferring is likely to be the target of an intelligence operation. Is an intelligence community very interested in SurveyMonkey results? Probably not. Is an intelligence committee very interested in international banking records? Could be. So I think that's step one, is conducting a risk assessment. I think step two is looking at technical means to manage the risk of interception. So that means looking at things like encryption in transit, looking at strong information interconnection controls like tokenization and secure socket layer transfers, things of that nature. And then I think finally, it's about managing risk through what data do you send over the Atlantic. And that's where programs like data residency and data localization really come into the fore, is if you can say, well, we're not really sending the bulk of our personal information to the United States, we're really only sending, I think the example was given earlier, login credentials or something like that. That really helps lower the risks and puts you in a more defensible position to assert that your SECs do provide adequate protections. In addition, the SECs are just one part of your normal commercial contract. And so in order to meet some of the CJAU's criticism around adequacy and redressability, meaning can data subjects hail the processor or controller into a US court to seek redress, we would strongly recommend considering adding some rights into your contract, again, carefully tailored to your situation, to perhaps provide some of those rights. And finally, we would recommend updating your privacy notices and disclosure packages in the United States. In the US, it's quite typical to have a clause that says we will cooperate with legal process, or we will share information in response to a valid request from law enforcement. It may make sense to be a little bit more assertive there and say that we will challenge those requests on your behalf to the maximum extent permitted by law, and really consider, are you willing to respond to a warrant, let's say, seeking EU resident data just as a matter of course, or would you seek to object and try to assert data subject rights? So that might be a good signal that you are taking data protection more seriously. Again, that's going to be a case-by-case determination, and one you should walk through carefully with your own counsel and make as a company.
That makes sense. Thanks, Peter. Our next asker gives the disclaimer that he doesn't, or they don't want this to be misconstrued as seeking legal advice, but they ask if US-based developers are looking at personal data in order to provide that support. Because they cannot hire up localized support, is your assessment that SEC with explicit user permission is adequate?
Well, those are two different things. So if you have express user permission, that is a derogation to the data transfer rules. It's called the consent permission, and that is fine. So you can independently do it without an SEC. But we do think that an SEC for support, again, if you take a risk-based approach, looking at the types of data that's being transferred and the types of data that are being processed in that support interaction, we think it's very defensible that an SEC provides adequate data protection rights. So again, this is going to come down to your individual use case and risk tolerance. But I do think that an SEC is defensible if you don't have the resources to establish a European support infrastructure. I think in my conversations with regulators, one of the things that I'm often advocating for, and I do think regulators here, is they cannot set regulatory goals that work for a Google and a Facebook who have very large resources, and then hope to have smaller or medium-sized companies have the same types of controls. We just can't afford them. And so the European regulators tend to be sensitive to that. They are not interested in creating a data protection regime that rewards large incumbents. They do want to foster innovation, and they are sensitive to that. And so if you have demonstrated a strong willingness to be compliant, you've stood up a thoughtful and reasoned approach, you've put in the right types of legal agreements, you're going to have strong arguments that whatever structure you land on is appropriate. And in my dealings with data protection authorities, they're often very grateful, A, that you've thought through the issues, And B, if they do have criticisms, they're not likely to levy fines. They're more likely to suggest ways to enhance your program and give you an opportunity to do that prior to issue a fining decision. So that would be some of the things to think through in a risk-based approach. But as you pointed out, I would strongly recommend you talk to your own counsel on that topic and get more specific advice that's tailored to your business.
Definitely. Great. Well, I think we're coming close to that time, so we're going to head into our last question. First, I just wanted to ask that our participants today take 2 minutes to complete a quick survey, which I'll drop in the chat right now. And with that, here's our last question. Are there signals that there may be a Privacy Shield 2.0 where incremental migration is agreed to be put in place by US/EU authorities because they haven't struck down SECs?
So that's another one of those tea leaf questions. The European Commission and the US Department of Commerce have been in talks since last year about what they at the time were framed as enhancing Privacy Shield. I do know that the Secretary Ross has signaled that he is willing to work in a multilateral fashion with European authorities to try to come up with a Privacy Shield 2.0, or maybe we could call it Safe Harbor 3.0. But that is something that I think is definitely a strong possibility. I don't know if it will occur, but looking at the timeline, which we explored a little bit earlier, that would buy us several years, at least prior to it going in front of the CJEU for review. That said, given the history here, I don't know if the outcome would be different. It may just be a delaying tactic. So again, it's a very interesting question, one that we would be happy to explore further on CPQ, or excuse me, QBQ. But we're all going to be waiting, I think, to see what this, how this plays out in the months ahead. And on that point, I did just want to briefly share some additional resources that we've put together. I know it can be very challenging to track and keep track of all of these different regulatory findings and where do I find information. So this again was prepared yesterday. There's more that's come, but I did want to flag a couple of resources for you around where you can find some guidance or thoughts. Obviously, I would pay close attention to the European Data Protection Board. I think they're going to be a key stakeholder going forward. We've linked to their press release. You can obviously track them on that website. Some other key guidance that I would point to are the Irish Data Protection Commissioner's press release in response to the decision. And obviously, as another sort of large data protection authority is the French CNIL. They've issued a very sort of wait and see guidance, but again, some resources for you as you continue to wrestle with these questions.
Wonderful. Well, thanks everyone for joining today, and thank you very much, Peter, for taking the time to chat with us. As Peter mentioned, we are going to be continuing the conversation on Mixpanel's community site, QBQ. We'll send out that information as well as the slides and a recording of today's session in a follow-up email that you should receive within a few hours. Thanks very much, everyone.
Yeah, thank you, everyone. Have a terrific rest of your day.